Good afternoon. Welcome to our live webinar, Corona Back to Work. This afternoon, my colleague Eileen Pluim and I will take you through some questions which relate to employees coming back to work after the Corona government measures. Eileen.
Hello, my name is Eileen Pluim. I work here and I specialize in labor law as well as dispute resolution. So together with Reinier, we've set up a Corona crisis team because we've received loads of questions from entrepreneurs, employers that are having legal problems now due to the coronavirus, as well as from employees that have questions regarding their working conditions during the corona crisis. So that's why we've decided to set up this webinar to answer some of the key questions that we have seen over the past 2 months.
I'm Reinier Russell, a lawyer for 30 years already and mainly active for businesses abroad and businesses with subsidiaries in the Netherlands, Dutch business, and a special part of our work is working for embassies in the Netherlands for their local staff contract work. Our clients are very happy with our work, so we are remunerated in the European Legal 500 for corporate work and for employment law. To give you some background on the program, businesses are opened soon. Tonight we have a new information coming from the Prime Minister on the new rules and when a business will reopen. Most probably it will be phased in several phases so that not everybody will go to work at once, immediately, all at one time. For example, in Germany, they are thinking on getting people to work between 20 and 50, and the other ones have to stay home. But it could also be that in the Netherlands we start with north and later on south and then the middle. We have to wait exactly, but that the employees will return to work, that is for sure. Lots of questions arise from this. If you have a question through our talk, you are able to do a chat question and we will try to immediately reply to your questions. To introduce the idea of Dutch labor law, Dutch law in general, you should think about reasonableness and fairness. That is the backbone of our civil code. Not everything is directly mentioned in our civil code, and if it's not mentioned, judges take the measure of reasonableness and fairness. And two other measurements is good employership and good employeeship. And well, if you work in a factory, there are different facts and different circumstances than when you work in a law office or at an embassy or in ICT. So facts and figures you have to take into account. Eileen.
Yeah, so these times are very new. It asks creativity as well as flexibility from both the employer and the employee. And that can first be seen in the fact that a lot of employees have been working from home on the advice of the government. So they've said, please work as much as possible from home. But this does give rise to new challenges for employers, mostly in the field of monitoring their employees. So first of all, as an employer, you have to create a safe and healthy workplace. And this also extends to the home workplace. But how can you check that as an employee? And that also counts for monitoring whether your data is protected at the home of the employees, the customer privacy is then ensured when people work from home. And last but not least, we receive a lot of questions about monitoring employees in the sense that do they actually perform their work when they are at home? So can there be a monitoring of the employees? And the answer to that, you have to keep in mind that this is a big intrusion on the privacy of the employee. So only under very strict criteria this can be done, but it can be done. So first of all, there has to be a legitimate reason for the intrusion of privacy. So does your reason as an employer outweigh the privacy of the employee? Then also you have to keep in mind that there is no other way of doing that. So for instance, in the sense of creating a safe and healthy workplace at home, you can ask your employees to set up a webcam all day long, but on the other hand, you could also ask your employees to fill in a checklist or sign a written statement about how the conditions of the workplace are. So is there no other way to reach that legitimate reason? Then the third criteria is that you have to give advance notice to your your employee. So they have to know that they can be monitored, they have to know how they can be monitored, and they also should know what is allowed and what is not allowed. And if you do something that is not allowed, what are the consequences? And then another thing to keep in mind when monitoring your employees is also do not monitor confidential information. So do not start reading private emails from your employees. That is not allowed. And last but not least, keep in mind that all the data that you collect during this monitoring has to be stored and collected in accordance with the GDPR, of course.
Sort of the same rules apply when you have cameras around under normal circumstances. Of course, for safety reasons, you can have cameras, but you cannot misuse the views of the camera for other reasons, because that is a violation of privacy law.
Yeah, so even in these times where Corona forces us to work from home, the GDPR privacy laws are still applicable, and keep in mind the criteria. You still have to meet them. This isn't changed by the fact that we are now obliged to all work at home.
Are employees obliged to come back to the office? Well, HR plays an important role. The right to issue instructions, that is what every employer has as a right, but you also on the other hand have good employer obligations and good employee obligations. Not all workplaces are already COVID safe. So offices where social distancing of 1.5 meters is not kept well, then we think employee can say, I don't come back because I'm not in a healthy position and I don't want to sit within 1.5 meters from another employee. What we think is, if you cannot change the work environment, that, for example, if you have 50 employees, that you do it in shifts, 10, 10, 10, but that changes a lot in working hours. Employers should also take hygiene measures, hand sanitizers, disinfectant wipes, office cleanings, extra office cleanings. All sorts of information should be exchanged with the employee. So that is why I said HR plays an important role. We think there's reason to make a HR COVID confident, somebody who is within the company, within the employer, the only one whom you can talk to see what in specific circumstances for every employee you should get into discussion with the employee what measures should be taken on the workspace.
So then we come to the question, what if you're asked as an employer what if you ask as an employer to your employees to come back to work, and your employee feels like it's not safe for his health, he's afraid of getting infected, so he refuses to come back. Does the employee have to come to the workplace if requested by the employer? Well, this all comes down to that in principle you have to do so if the work environment is safe and healthy, as should be made by the employer. So if your employer has provided such a workplace and you're requested to come, you in principle do have to come back to the workplace. But there is this, you do have to keep in mind good employership, good employership. So if your employee says that he has certain health conditions that makes him unable to come back to work, or he's chronically ill, maybe pregnancy, all these things can change this, that the employee can in fact request to continue working from home. So it all comes down to the facts and circumstances. So the health conditions of the employee, as well as is he able to work from home? If he's able to work from home just as well as he's able to work at the workplace, then it's more reasonable to allow this employee to work from home. And that also counts for maybe he has to take public transportation to his work. So you really have to balance all those circumstances and come to the conclusion that maybe in some cases the employee is allowed to refuse to come back to the office, but starting point is they have to come if you provide a safe and healthy work environment. Just the fear alone of getting infected, that is not good enough reason to refuse to come. It really has to be specific health condition or some other ground that the employee can substantiate. So what if your employee does not have a reasonable ground to refuse to come, and he just doesn't come even though you have discussed it with him? Can you take as an employer measures against this? Well, that is possible. You can, for instance, stop the salary payment after a formal warning, and in some cases it can even lead to termination of the employment contract. But do keep in mind that in these days, with the uncertain circumstances due to coronavirus, the judge may not award a request to terminate the contract based on the fact that, yeah, it's really difficult to weigh the good employee, good employership in this circumstance.
Next question is exactly the other way around. The employer doesn't want the employee to come, but the employee wants to come. We think it's very necessary that employers give regular information on their COVID policy. If at a certain moment you want to come to a judge, you have to make clear what is your COVID policy. And your COVID policy 3 weeks ago is different than your COVID policy within the next month and the next years. So make clear, and that very much depends on the line of business and the line of duty of work which has to be performed. Make clear to your employees what is and what is not expected from them. Can you deny access to employees? Yes, in general you can. But make clear when are you eligible for work and when are you not. If you are ill, please stay home. I think that's the national code of our Prime Minister. If you feel illness, if you don't taste anything, if you don't feel well, stay at home and don't come to work. So even the employer can still say, I don't want you to come to work. The employer is responsible for providing a safe and healthy work environment, and that also means that you do not allow sick people to the workplace, because what we have seen in some cases, we've all read it in the newspaper, I think, that where in companies 1 or 2 people are ill, it could easily become 40, 45 people getting ill. And that's not bad employeeship, that's not bad employership, but you should both work on good environments. And you have to take, as an employer, have to take care of the safety and health of the other employers. So you have to bear in mind and make everybody sure that they stay away. You have to send them away if you feel that something is wrong. Can you take temperature of employees? In general, no, because privacy law, which was implemented in May last year, is very strict in the Netherlands, and taking temperature is private information of an employee. In normal office spaces, I would say no, no, no. In special circumstances, for example, the chip manufacturer ASML, they do temperature measurements because they work in very solid and safe surroundings, but most probably these have been negotiated with either the Works Council and or the unions, and the facts and situation over there is very special compared to a normal office. So yes, you can deny employees to come to the office, even you have to deny employees to come to the office if you feel in any way that they are ill whatsoever. Back to work, business as usual. No, unfortunately, back to work, it's not business as usual. Depends on the business you're doing. But in diplomacy, your business is shaking hands, going to receptions. In sales, your business is going abroad, going to fairs. Is that business as usual? It depends also, again, can you do it from home? Can you do it through Zoom, WebEx, things like that? You have to take it company per company and make it clear in your policy, and your policy is not for the next 2 or 5 years, because what counts today can be different within a month, and maybe in September we have some cure that will change the situation completely. But traveling abroad now is not a reasonable request, I think. Changing contracts, can COVID be a reason to change contracts? We got one question, a request back in April, that the employer said the government is taking over half of the salary. We want to change your contract from 100% to 50%, and the employee signed the contract. That is not a reasonable request. The question is whether the employee understood the request, yes or no, or that he or she was misled. But COVID is not a reason to change contracts. We have two ideas in Dutch law, that is force majeure and unforeseen circumstances. In China, force majeure, COVID counts as force majeure. So if you have to deliver whatever product and the factory cannot deliver, then there's no reason to pay any damages. There's reason to change the contract. But in the Netherlands, in general, COVID is not a reason to change any contract. For example, KLM gets 2 billion government subsidy now, and the main part of this 2 billion goes to buying fuel, because KLM has long-term buying contracts for fuel, and even if they don't use fuel, they still have to pay for the fuel and take off the fuel. So in general, there's no reason to change contracts. So what if your employee cannot do his work? He has to travel, he has to do sales. Has to be seen in the specific circumstances, whether you can give other work or safety measures can be taken, that the work can be done remotely through Zoom, WebEx, or things like that.
So we move on to the holidays. We've received lots of questions in this context from employers, like can they refuse an employee's request to take holidays, as well as from employees when their trip is cancelled, for instance. So first, from the point of view of employers, can you refuse an employee's request to take holidays? Well, that can be done, but only in case of major business interests. So the main principle in Dutch law is that the holidays are scheduled according to the wishes of the employee. And if the employer has a major business interest, he can refuse such a request. So in this case, you have to think of your manufacturing hand sanitizers and there's a rush order and you have to have all hands on deck and everybody has to stay home. Well, in that case, you can refuse a request. Can you oblige employees to take holidays? Well, in principle, that cannot be done. You cannot force your employees to take holidays now. This is only different if there is something in the collective agreement or the employment contract which allows you to appoint a certain number of days as days off. But the main principle is you cannot oblige your employees to take holidays. However, if your financial situation is really tight and there is no other option, you do again have the good employeeship that in some cases you might require that, but the main principle you should keep in mind is no. Then last one, for the employer's point of view, can you stipulate that employees can only carry over a maximum number of holidays to the next year? No, that cannot be done. Holidays, they lapse after a certain period of time, so you can make employees aware of that, but you cannot say you can only take maybe 3 years or so to the next year. You cannot limit that amount. So then from the employee's point of view, what if your trip is cancelled? Can you ask your employer to take back all the holidays? And no, that is not the case. Usually when you have a cancelled holiday, but you have already been awarded to take these holidays off, the principle is taken is taken. So your employer does not have to agree with you getting back your holidays, but well, if you're at the moment flooded with work, you can of course accept this as an employer. And then the last one, in the area of holidays, can you request your employer to pay out your holidays? As said, holidays do lapse after a certain period of time. So the statutory holidays lapse after 6 months and then the non-statutory holidays after 5 years. And this means that the holidays accrued in 2019 will lapse, the statutory holidays will lapse in June 2020. So that's very soon. While most employers didn't go on holidays so far because of the coronavirus, not being able to go abroad is something that have put the taking holidays, have stopped them from taking holidays. So they might want to have those holidays paid out, but that in the case of statutory holidays cannot be done, and in the case of non-statutory holidays can only be done if such an arrangement is laid out in the employment contract, so only in a limited number of occasions that can be done.
We got some anonymous questions and specific questions. I will deal with a few of them. One question is, employees has mental health issues such as anxiety and depression. It is known with the Arbo doctor and HR. Is this a reasonable ground not to come back to work? Well, mental issues health issues are not something which you can discuss between employer and employee in the Netherlands. So this is dealt with, unfortunately, by the Arbo doctor. So if this is the reason, I think the employer has the obligation to make the health circumstances reasonable within the workplace, and the employee should be sent to the Arbo doctor to see how this can be solved. Then we got a question from Zolt Fürstli. Welcome, Zolt. Is there a difference between home office and remote working in your law? What happens if the employee comes back to work, but then he thinks that the safe work conditions are not guaranteed? Well, if that's reasonable, then it's most probably reasonable that he or she goes home if the work can be performed from home. But for example, if you have a performing job, you're a waiter or a plumber, then it's not reasonable, because that work cannot be done in a different way. But if the office space is not guaranteed and the work can be done from home, if you are a waiter, you cannot do the work from home. So yes, if the work can be done remotely by computer, then it's most probably reasonable that you do it from home. But start negotiations between HR and employee, how to safeguard the safe work environment.
There's also the Works Council can play a part in this as well, so they can address this to the employer in light of their right to give to be consulted, to be informed. So they can discuss this with the employee, so they can discuss all the measures that should be taken in light of the hygiene and the 1.5 meters distance, etc.
Then there is a question: due to the crisis of Corona, rules for dismissal employees are being more flexible. That's not what I expect, but are the new rules already valid, and how can we as an embassy apply the rule in case we need to reduce the number of our employees? Well, what we see now is many business, nearly 100,000 businesses have applied for the NOW government ruling that, let's say, 3 months the government will pay a percentage of your personnel costs. We do not think that dismissal rules will be easier. When you make use of NOW, you may not dismiss, but after the NOW rules, we think many more dismissals will be the case, but that's not due to Corona, that is due to change of work circumstances, economical situation, and whether the economical situation is applicable to an embassy, that is the question, because there's not less work, there's not different work, so that has to be seen from case to case. But if your turnover has dropped with 50%, it's reasonable that you will dismiss one or more employees. Then we go back to the sheets. Can employers postpone an employee bonus or holiday allowance? As I told you earlier, COVID is not a reason to change a contract. So bonus, in principle, you cannot change it. You have to look at the employment contract, the bonus scheme, maybe there's a collective agreement or a personnel handbook, but in general, if you are imposed on a bonus, then the bonus has to be paid. In case of late payments, statutory increase is due up to 50%. What we see a lot is that employers ask all their employees, let's say football players, are asked to up to 30% to give back to the employer. That's a voluntary thing between employer and employee, but an employee is not obliged to do so. Holiday allowance, normally it has to be paid in May. So in May, every employer has double costs. Also there, in principle, you cannot change it. Payment is once per year. It's put in the employment contract that it is paid in May or June or in the collective labor agreement. So it has to be paid, and late payments will lead to a statutory increase up to 50%. This is all in the Minimum Wage Act and Minimum Holiday Allowance Act. Can employers dismiss employee if there's not enough work anymore? That will be in many cases the case. Usually dismissal for business economic reasons. You file an application with the UWV to obtain a dismissal permit or a settlement agreement. It will be more difficult for employees to get a new job, so they will not easily say goodbye to their old employer, but also they're reasonable in fairness. If you make a reasonable settlement, it might be that your employee is willing to sign. Temporary emergency measure for the prevention of work, NOW. During, as I said to you before, during NOW you may not dismiss for business economical reasons, and employers may not apply for UWV dismissal permit, but a settlement agreement is possible during NOW, and when the NOW period is over, settlement agreements and dismissals are possible again. But in general, it's more economical reasons, performance reasons, that you perform less during COVID is very normal. So that's highly unlikely, and COVID in itself is not a reason for dismissal, the new working environment. A question came in. Governments get their funds usually from tax payments, etc. When economy goes down, the funds to the government institutions go down. Therefore, the budgets for embassy go down. Therefore, you need to dismiss employees. Is that a reason to dismiss? Unfortunately, governments are seen like a tree with apples, and every time you shake the tree, apples fall down. So whether 100 apples or 99 fall down, I do not think that government tax payment issues are reason to change or end a labor relationship. But if the work performed, the daily work load is performed differently, or there's less work, that should be reason to dismiss.
Yeah, it can be, for instance, that you at the moment have a social media team or a marketing team, and that during this corona crisis you feel like you want to close that department. So reorganization in that sense, that can qualify as a business economic reason for dismissal.
This is a very nice, okay, go a little up.
Oh, sorry.
So this is a very nice question. What if an office employee decides to transfer a second or family home, for example in Spain, and works remotely from there while they are not able to return to the office? Well, it could have been a few months ago that you got stuck abroad, whether it's on holidays or when you were on business travel. That is something which is part of the employer's risk. Did the employee, him or herself, think, well, it's wise for me to go to Spain because I have a second home there and the sun is shining even more there? Then it should come for the for the risk of the employee, of course, because depends on when he or she went there and whether it's a normal pattern. But then you take up the risk yourselves. It's like if you're in your spare time, you're a boxing champion, you get hit over the weekend. It's a risk you take as an employee, and it's not normal in certain fields that you take such a hobby which doesn't allow you to work. One more question. Hello, thank you for the webinar. I just wanted to ask the following. Should all health matters of the employee be discussed through the company doctor? Never directly employer-employee. It is mandatory to have a company doctor. Yes, in the Netherlands it's mandatory to have an ARBO doctor because GDPR is very strict. Even if your female employee comes in with the very thick belly, you may not ask, a little bit exaggerated, whether she is pregnant, yes or no. Illness-related things should be dealt with by the company doctor, and even the company doctor is not allowed to inform the employer on the facts and circumstances of the illness.
Yeah, assessment of being ill is never up to the employer, that's up to the ARBO doctor. So we're at our last sheet, and it goes into the role of the Works Council. The Works Council should not be forgotten during the Corona crisis outbreak. Also during the Corona crisis outbreak, they have the right to be consulted, the right of consent, and the right to be informed, and they have the right to initiate proposals. So they have to be consulted with regard to major decisions of the entrepreneur. So this goes to decisions that have a long or far-reaching influence on the day-to-day organization, so reorganization, for instance. The Works Council also has a right of consent when it comes to adopting or revoking certain social matters, such as regulation on working conditions. Well, during this Corona crisis, a lot of those regulations are only temporarily. So working from home is, in some cases, only temporarily, but some may end up being enduring or have irreversible consequences. And if that is the case, the Works Council needs to give its consent. So you can think of regulation on work from home, or the monitoring of employees, or the changing of working hours of employees. That all gives rise to a right of consent. And then the last one being the right to information and initiative, as already said by us in this context. For instance, the hygiene measures, that can be a point of attention for the Works Council to discuss with the employer. So that brings us to the end of our webinar. Hopefully we've answered all your questions. We'll check after the webinar. Thank you so much for joining us. If any questions come up a little later, please feel free to contact us. The contact information is on the screen right now.
I see one more question. Can we still apply for NOW? Yes, you can still apply for NOW, but one of the criteria, or the specific criterion, is that your turnover is more than 20% lower than the same period last year, and it depends on the employer whether there is a turnover. So if it's a laboratory with no turnover, for example, then you don't have a lower turnover, so then you do not apply for NOW. Very strange, but yes. Employees with children, can they work less hours? Well, there is a law, the law on adjustment of working hours. So first of all, if you have sick people at home, you can ask for sick leave, not only sick leave for yourself, but to help somebody else. But in this case, there's an act that says that at any time, if you work 40 hours, you can ask to work 32 hours or 3 days a week. Should be in writing, and within 1 month, the employer should reply to the employee whether this is possible, yes or no, and what the strict circumstances are, why you cannot work less hours. In general, this also depends on the facts and circumstances within the employee's business, whether it's possible, yes or no, but it cannot be ignored, such a request of the employee.
Yeah, if it's only a temporary request, you can also discuss with the employee to maybe accept taking unpaid leave or taking holidays, just for now as a compromise for both parties.
And children are going back to school, so there's no reason in that respect. Is these all the questions?
Oh.
1, 2 more. Would you be so kind to send the presentation to our emails? Yes, you will all receive an email afterwards, and you can find the whole presentation. It was recorded and it will be published on our website. Zsolt thanks us very much. It was quite useful and informative. Thank you all for participating and for your questions, which you sent already up front and during the presentation. It was our pleasure to be in contact with you in these corona circumstances, and hope to see you soon. Bye-bye.